All right, everybody. Welcome back to a brand new look for our Canadian Immigration Live Q&A. Instead of having Alicia and myself, we have invited Igor to join us. He's going to be moderating and working the magic in the background. We got a new look, a new feel to this, which you guys have seen a little bit because we've been testing out this new overlay for our live streams. But it's great to have the team all together here, and we're excited to have you joining us. So how are things going for you guys? How are you doing, Alicia?
Doing all right, Mark. And Igor and I were just chatting about the round of invitations yesterday on the first CEC that they've actually done since the points were taken away for arranged employment. And so it's high, it's very high.
Yeah, and I'm doing good as well. So, enjoying the first warm days of the spring because it was
Indeed.
pretty cold the last couple of days.
Yeah, indeed. So, you guys, we have a new immigration minister. So, what are your thoughts on that?
Alicia?
Maybe, Igor, you can take it away. You actually wrote a whole blog article about this yesterday and went live.
Yeah, I am pretty excited to be honest. I'm excited to see that uh, she has some background in law. She was a lawyer. She was a minister of immigration in Nova Scotia for a number of years. She has placed a heavy emphasis on uh, collaboration with the employers locally in the provinces, attracting more international students and actually retaining those. And she also had heavy emphasis on francophone immigration. So I think the choice is not coincidental. She was carefully picked among all available candidates. It's a little though questionable how well she will perform on a national scale because yes, the nature of the issues is about the same, but the scale is um, way larger. So I am positive, I'm hopeful, but I'm also a little careful making my own predictions right now.
Yeah. Well, that's the best part of this is that nobody really knows. So we can predict and prognosticate all we want to prognosticate. And I am optimistic as well. I think, yes, there's a little bit more of a broad brush that's being applied to the federal immigration minister portfolio compared to what the minister had uh, basic responsibility over for the province of Nova Scotia. But she's at least got a background in it, you guys. And I get the sense, at least I'm hopeful, that she will have a little more empathy and compassion than Minister Miller, who I think was put in there as as an axer and a slasher, and someone who had to try to reverse course, as he indicated himself. But I'm very optimistic with the new minister, and I'm hopeful that the empathy and compassion will show through. I'm hopeful that they will reverse some of the things that they're doing now. And like we talked about yesterday, Igor, even if they return the PNP numbers back to what they were before, even if they can just do that at the beginning as the first step, that would be my appeal. And then go from there in terms of just realizing that every individual here that's on a work permit who sacrificed so much to be here is a real human being and deserving of some consideration. So that's my hope.
Yeah, and I probably also would add, Mark Carney said that they've heard what people had to say, what people wanted to see, and the goal is to make one economy out of 13, at the same time hearing what provinces really want. And if he said that we're going to listen to the provinces, that kind of gives me a hint that perhaps, yes, they will shift more burden of immigration towards the provinces and will retain only some key immigration pathways federally, but economic immigration will be driven by the provinces.
Yeah, and I guess the thing that remains to be seen is how quickly will all these things happen, because we know that Mark Carney has said they're going to keep those targets that they had set under the levels plan, and so we know that that's going to be declining the overall numbers in terms of temporary residents and permanent residents, and they're going to stick to their guns on that. So, there's not a lot of wiggle room within that stricture to try to do things that are super compassionate or that are going to give new options for people. So it really seems like, okay, well, assume that it's status quo, assume that it's business as usual. And how are you going to maximize your points? How are you going to try to outlast other people whose work permits might be expiring? And how are you going to try to maintain valid ability to work or temporary status? And if you can't, then think about going home and getting that foreign work experience.
Absolutely. Guys, we have quite a few people piling in already. We have quite a few questions, so I propose that we move on to the questions. Before we proceed forward, just a reminder to everyone, we are all three Canadian immigration lawyers, the Holthe Immigration Law. So if you have a very specific question applicable just to your situation that starts with can I, should I, and so on, we would direct you to book a consultation through the link that you see on the screen. If you are more a DIYer at heart and you don't have a specific question, but you just need some extra guidance as to how to fill out the forms, what to watch out for, you can check out our courses at CanadianImmigrationInstitute.com. You can also see the link on the screen out there. All right, so we do have a few questions in the list. Sometimes I will go randomly through the questions. I'll try to go in the order in which they're received. If we receive a super chat, we'll give a priority to that question, and then we'll try to come back to the list. So the first one we've got was from Mumi. Should we expect small CC draws in the future? What is your prediction? 515 points in here.
Yeah, so maybe Igor, you can flip quickly to the last rounds of invitation, which happened yesterday. They only pulled 500 people, and that is why the CRS score is astronomically high. So yes, if we zoom in on this, 547. So Mark, I think when we were rubbing the crystal ball before, we were not high enough, right? This is a very, very high CRS score. The reason is because they only pulled 500 people. So they are literally scooping off the cream at the very top of this pool. And it is tough because if you look at the tie-breaking rule, that's all the way back to last year. So people who have a profile that's basically just about to expire, these are the people who won out in the tie-breaking rule. So if you had exactly 547 and you had your profile sitting in the express entry pool and it was valid since last year, May 21st, 2024, then you are one of the lucky people who hopefully got that round of invitation.
Yeah. And what is causing the CRS scores to be so high? I think notwithstanding the removal of job offer points, it is no secret. And we talk about this every single time we get on these live streams. And every time we're talking about the inner workings of express entry and how to prepare, how to increase your score, how to give yourself the greatest chance of becoming a permanent resident. Well, once the election results came rolling in, I hope it is very apparent to everyone that if you're looking to immigrate to Canada, start learning French. If you are here looking for a way to stay, start learning French. If you're running out of time and you're trying to find the fastest way to gain some points, start learning French. And with the bonus points that are given for express entry, you have options under the Francophone category specific draw. So Francophone alone, if you have scores that are very, very modest, you're getting through. But on top of that, when I see CEC and I see even PNP to some extent, those high CRS scores are greatly influenced by French. And if you do the math, there are upwards of, I think, 74 total points if you're completely fluent in French, in addition to everything else. And that is a massive swing and a game changer, you guys.
Yep. All right. On that note, we'll move on to the next comment that we've got. And this one is from Raphael. I just pulled it up. Raphael thinks that after yesterday, it's clear that they want to empty Canada from temporary people. Any comments on that, guys?
It wasn't after yesterday, my friend Raphael. It's been ever since the announcement happened last fall that they were cleaning things out. So no surprises here. The question is, and this is something legitimately I had a question, was whether or not it was purely political and that the Liberal government would reverse their policies and return back to the direction that they were heading. With the large numbers of individuals, the problem really is infrastructure in Canada. And so, we need to build more houses. We need to have more doctors and nurses and healthcare and all the social networks that are really the crown jewel for our country, Canada. And when those services are overtaxed and we don't have the resources to care for the people that are here, that's when things start to stumble. And that's really why Canada had the problems that they did. And it wasn't that the lofty goals for numbers were misplaced. It was just the infrastructure wasn't quite in place to handle them as quickly as they came in. So I don't know, Alicia, Igor, what you guys think, but I suspect that they, maybe not this year, but next year for sure. I think we're going to see the levels plans readjusted again. But what are your thoughts?
Alicia, I'll
We'll
let you
see.
go first.
The political climate has changed a lot, right? So we see that things are being affected by what's happening south of the border, by what's happening in Europe. And we do definitely see a pushback, a little bit more of every country for itself kind of mentality. And when we look at the birth rates, when we look at the fact that Canada just has an aging population, people are retiring from the workforce, and if we want to stay competitive and we want to have enough of a workforce and productivity to support that GDP, we need active, productive people. And from being in immigration for the last 20 years and talking to people and looking at the drive and the ingenuity and the fact that so many immigrants have international experience, they're risk takers, they learn languages, and they're willing to work 2 or 3 jobs at a time. There's a lot of potential there. So I agree with you, Mark. The infrastructure needs to be there because that's where we start to see suffering, where people don't have places to live, where people can't afford groceries, where people like the housing is huge, but that is not to blame it on immigrants, right? Like these are systemic problems that often are not federal government, right? That's usually municipal, it's usually provincial in terms of infrastructure, roads, housing, services, healthcare. Most of that is not federal. But now, of course, the federal government has to manage immigration because it's federal jurisdiction. So there are a lot of tensions, and we understand that there are a lot of competing interests. And so we'll see. I suspect that they may stick to the smaller targets, but we will have to see what happens with the levels plan for next year.
The next comment we've got was from Dana. Dana says that we have a new great format. So I'm really happy to see that people like it. Okay.
And if you didn't get a chance to watch the video yesterday that we did on the new minister, we did take some time, at least I did, just to share a little bit of Igor's journey with the viewers. And if you haven't had a chance to go back and watch that video, because sometimes people just think, oh, some people just have it so easy. The path is just all laid out for them, but my situation is just really tough and unfair. And we talked about a couple things yesterday. We talked one about Igor's journey, and I'm not going to put any spoilers out there. Go back and watch that live stream. But we also talked about some other applicants who went to great lengths to position themselves to secure an ITA, and that's the nature of the competition that exists within our immigration process right now.
Well, I'll pull up the super chat from Raphael. Will they continue approving LMAs for Tier 1?
Yeah.
Yes, if it's a high wage occupation. And so the problem is it's going to take forever. And so this is the real issue, that theoretically an employer can advertise and recruit. They have to do so 4 weeks continuous, but it has to be a high wage occupation. If it's a low wage occupation, then you're caught by the unemployment caps and the zones of which census metropolitan area are you working in. So if you're in a CMA and it's a low wage occupation and the unemployment rate is higher than 6, no go. You're grounded. There's no way that LMIA is going to be processed. However, if it is a high wage occupation and the employer legitimately cannot find a Canadian to fill that role and they can prove that with their recruitment efforts, they can file that online LMIA application. The last one that I had submitted with an employer took 10 months. Now we're hearing it's 12 months. The website for LMIA processing times from ESDC says something like 76 business days, which is just not
Wrong.
correct.
That is not accurate.
Yeah. Yeah.
Okay. Okay, so the next question is from Jimmy. Is it possible to sponsor a partner if we have a long-term distance relationship?
Alicia has a really good blog post on our website that covers the inner workings of in Canada or family class sponsorship. And I guess the one thing I'll say, Jimmy, is that it depends on the nature of your relationship. So if you are trying to claim that you are a common law couple, so you're not married, then that can be problematic with long-term, more distance relationships. And obviously, every single individual relationship is different. The mechanics, how it's set up, the history, the evolution of the relationship are all a little bit different. And we're doing a ton of spousal sponsorships right now. But when it comes to a long-term distance relationship, you're basically asking the question, do I meet the definition of a spouse to be eligible to be entered into one of these programs, the in Canada or the family class? And when you have a long distance relationship or a long-term long distance relationship, I'm assuming the other person is outside of Canada. And in those circumstances, it becomes really difficult to establish that you are common law when you're separated, or conjugal, as we often refer to it, without some pretty exceptional circumstances explaining why you're not able to be together. I'll let Alicia dive into that a little bit more, that particular topic. But generally speaking, if you are married, then that removes some of the barriers that exist with respect to long distance relationships if you're a married couple. But Alicia, the challenges of common law, the whole world of conjugal, lots of people, think, hey, we can just file a conjugal application, but it's not
Yeah.
that easy, is it?
No. And so, Jimmy, the first question I'd ask is, are you just in a long-term relationship? Like, are you fiancés or are you just dating? And if that's the case, then no go. You cannot file a spousal. Next thing is, okay, are you legally married? Because that's easy. If you're legally married and the marriage occurred in the place where it was legal in the place where it occurred, then great. You're probably legally married, and then you just have to show evidence of the fact that it's a bona fide relationship, that it's not a marriage for immigration purposes or a marriage of convenience, that you actually meet the test for being spouses. This is where the rubber hits the road, though, for the conjugal or the common law. So conjugal is not possible if it's an in-Canada relationship, but it could be possible if it's an outside Canada relationship. In very few cases do people file conjugal relationships application sponsorships. It's only usually if there's some legal impediment to being together and you literally cannot live together. But you do know each other in the biblical sense, I will say. Common law is 12 months continuous cohabitation. And so you'd have to prove, to meet the common law definition, that you have been residing together and you've got the evidence to show that. It's much harder to show 12 months continuous cohabitation if it was a long time ago. But if you've never lived together for 12 months continuous, you will not be able to meet that common law spouse definition. The other thing to keep in mind is if you are looking at a conjugal or a common law relationship, if either of you strayed, if you may have had a relationship with a different person, it can reset the clock on when you can count your 1 year of continuous cohab. So there are many things to think about. Do take a read of that article. The one thing I will say on that article is I do have to update it, or I should write a separate article on the temporary public policy with respect to the possibility for certain people who have filed a family class application to actually get a work permit if they happen to be inside Canada and they have acknowledgement of receipt on their family class application. So there is one little variation and nuance, but it doesn't apply to Jimmy here. So Jimmy, please book a consult if you've got questions about this, and we can go from there.
And I'll put one little caveat in there with Alicia. This is the great thing about being able to sit and listen to all these great answers. There's always going to be a little exception or a little variation from what we're telling you based on the specific circumstances of your case. That's why whenever you say, can I or should I, we always direct you to book a consult. So in some really rare situations, the nature in which you were married also can play a role, because Canada doesn't really like proxy weddings very much. But the interesting thing is in the US, a number of states actually authorize it. Some are just flat out double proxy, like neither person needs to be present. In a number of states, though, if you're a military personnel, there are exceptions that allow you to get married by proxy. If you are, because you're in a war-torn country, you're serving active military. So those types of weddings can be excluded. And there's a whole history behind the whole world of proxy weddings that we're not going to get into, and why IRCC, Canada Immigration, decided to not accept those as valid weddings. But just know that, yeah, if you have any kind of a unique situation, or even if you're just trying to figure out what the next steps are, we absolutely love it when you book consults early on, even before you get married, or you're just thinking about it. I've got 2 kids that are getting married to Americans, and we're filing permanent resident applications, spousal sponsorship for both of them. So yeah, there's no shortage of these types of applications these days, for sure.
Yeah. Perfect. So let's move on to the next question, because we're a little bit behind the schedule with the number of questions that we've got. So this one is from Chrisdell. So Chrisdell is a transgender woman from Asia, been transitioning for 6+ years. And the question is, am I eligible to apply for any pathway residence towards the permanent residence here in Canada? I'm living here as an international student in Ontario.
This is a great question. Hey, Igor. It's right in our wheelhouse. So the first thing, yeah, there you go. The first thing that we always say, Chrisdell, is that you're going to pursue every option that is available to you. As an international student, you're going to follow the regular process, get your postgrad work permit after you graduate, explore the economic PR pathways and programs. Igor and I did have fairly recently a wonderful success for another transgender person who we applied through the humanitarian and compassionate process, because that individual had run out of options, and through really no fault of their own, they found themselves without a pathway to permanent residence. And so in that case, the humanitarian and compassion option was a very viable option, because that individual was in the midst of transitioning. And there were a number of factors. So once again, consult probably is the direction to go, Christelle.
Yeah. All right. Before we jump to the super chats, quickly just wanted to pull up the question from Juan. So Juan said, I ran some numbers today, just 34,000 invitations for 2025, and the target is 395. We're already in May, less than 30% are taken. More chances for next month. What do you think?
Maybe we can clarify that. Leisha, I'll let you tackle that one. Yeah, there we go.
So it's rolling intakes, right? And so there's always an inventory. And so at the end of last year, in December of 2024, they had done invitations. They were still doing rounds of invitations. And so when they issue that ITA, then people have 60 days to submit their EAPR. Some do that sooner, some do it later. And then all of that goes into the inventory. And so these are rolling numbers, and it is a target. And if we look at the low and high and target range, there's quite a bit of latitude. So one, I agree with you. I think the rounds of invitation volume is probably pretty low for this winter and spring so far. And I think it's largely because there's been a lot of fluctuation with respect to taking away those LMIA points. And so they were being pretty conservative and, no pun intended, but they were trying to figure out what was going to
Mhm.
happen with the government. And so they didn't want to shake the boat too much until they knew the election results. And then now we know that there's a new Minister of Immigration. And so they will receive marching orders pretty soon, probably with those letters to try to say, okay, what direction does Mark Carney want the new immigration minister, Lena Diab, to go with in terms of what's the direction for immigration?
Yeah. And just to point out too, Juan, the 395 is overall numbers. So that includes all the categories, not just economic. And if Igor just goes down to the bottom of the economic section, what we're looking at is just up just a little bit. The total economic is 232,150. And probably when we're looking at invitations, the best numbers for us to look at are actually the top two categories on the left there, the federal economic priorities and the in Canada focus. So we have roughly about, what is that, about 123, 24 and change thousand. So that's kind of the overall numbers that they are targeting for express entry. And so, yeah, they're cautious and they're just kind of feeling their way through things. But those numbers, Prime Minister Carney, I think he is, he's very pro growth through immigration. And I think generally speaking, the Liberal Party are that way. And for all intents and purposes, I think most Canadians, if you ask them honestly, understand the importance of immigration to the long-term success of our country. And we are not replacing the workforce with our birth rates the way they are in Canada. And so immigration is the way to do that, because we are a socialist country. We're a country that relies on everybody pitching in, everybody paying taxes, and then sharing equally in the benefits of that collective approach, where our healthcare, our schools, education, all of those things are shared responsibilities of all Canadians. But we need people working to pay the taxes to fund those various social programs. So.
Okay. So next one is the super chat from Nash. Does the job offer in express entry always exclude postgrad work permit holders? And I understand the question is, if you are a postgrad work permit holder and you have a job offer from the Canadian employer, does that always mean that you will not get points?
Okay, Nash.
Maybe we can explain how the job offer points used to work.
And maybe, Igor, you can flip to my blog article, because I used to have a whole blog article with all the scenarios, scenario 1, 2, 3, in terms of who can claim arranged employment points. Now that immigration has taken away the 50 or the 200 points for arranged employment under the calculator for CRS, it is still relevant and still important to try to figure out if you meet the definition of arranged employment in terms of minimum eligibility for the points grid, for the selection factor grid for FSW. So that's still those still count. So arranged employment points still count for FSW. And it also still has a bearing on who has to prove settlement funds. But to answer your question, Nash, under these three scenarios, there is no scenario where you can ever have an open work permit and claim arranged employment points. I will say that again. There is no scenario where you can have an open work permit and claim arranged employment points. The only times that you can claim those arranged employment points would be if you have a closed work permit. That means it has to be employer specific. And so there are three different scenarios under which you might be able to qualify, but all of them require a closed work permit.
Yeah. And I guess theoretically, scenario one, if you have a permanent labor market impact assessment, in the old days, you could technically be on an open work permit, and then your employer goes out and gets an LMIA for you that's just permanent to support permanent residents. But, those days are, by and large, they're in the past.
Yeah. All right, Delara says, I've replied to a procedural fairness letter
Mm,
1 month and 20 days ago, and there's
yeah.
no answers till now. How do I how long does it take to have an answer?
Boy, we've got a lot of these. Like right after we're done here, I have 2 reviews with 2 separate clients in responding to these procedural fairness letters. Delara, be grateful. Okay. Time is on your side. So when they are taking more time to think about these things, that's not a bad thing. Because if they don't like what they see when you respond, it's very easy for them to just refuse quickly. And I have seen people get responses in a week. Delara, you don't want a 1 week response because it's going to be, I'm not satisfied. Either we feel you've misrepresented or we feel you do not meet the requirements of the program you're applying for. And so 1 month and 20 days is actually a positive thing. I'm not saying it means your application is going to get approved. I wish you would have reached out to us and engaged us to assist in responding. But time is actually, that's a positive for you.
And I'll jump in here and say, Delara, you can still reach out, right? Like, I think Igor's got some time because there are federal court cases on point that say if you have submitted additional submissions, you've properly submitted that through a web form, immigration has not yet made a decision, then the officer ought to consider that. So if you maybe didn't do a thorough enough job when you submitted your response and you want to get a little bit of a second opinion on what did you say, what were they concerned about, please book a consult because it is still possible if there's something that you missed to come back and provide further submissions and get that in via web form. Make sure that you do it properly because if you don't send that to the officer and it's not on file, there's no obligation for them to consider it.
And they're being kind of mean right now. My one client, they only gave them 7 days to respond, and they asked for updated Schedule A's. They asked for an updated letter from the employer, and it just so happens right now the employer is traveling internationally. And so this 7 days is very cruel, and they're actually not going to be able to get an updated reference letter from the employer before the time passes. So we're going to do the very best we can. We're going to submit what we have. We're going to ask them for an extension of time to provide the reference letter from the employer as soon as they get back from their business trip. And once we've got that, then we're going to have to upload it through the IRCC web form because the IRCC secure account in the document checklist where they have that little spot for you to upload. Once we upload it and submit it, it'll be closed. So we're going to use whatever avenue we have to try to do the best we can in the circumstances. And I think 7 days for a comprehensive response like that is pretty cruel, but they're, you know, like was stated previously, they are interested in lots of people leaving the country. And if they refuse a PR and the person doesn't have a means of extending a work permit, then the only option is to return home for the time being. So,
Yeah. So the next question is from ACNCA. Hi, Alicia, Mark, and Igor. Is it okay to move spouses' foreign work experience to personal history post-ITA?
I think I had a consult just yesterday with ACNCA. They just told me, hey, I'm ACNCA. So welcome to the live stream. Go ahead, Alicia. I'll let you tackle this one.
This is a question we get a lot, and it's because people don't realize that the principal applicant is never going to get points for a spouse's foreign work experience. So when you take a look at the selection factor grid for express entry, you will see that if you have an accompanying spouse, the only reason that the principal applicant's going to get points from the spouse would be the spouse's language, so standardized language testing, English or French, the spouse's education with a education credential assessment, or the spouse's Canadian qualifying work experience. Only Canadian. That's the only thing. Has to be 1 year, has to meet all the requirements. Mark and I just actually recorded a podcast. It'll be coming out shortly on Canadian work experience and making sure that you get it right. So if you mistakenly had put that in your express entry profile in your claimed points and you realize, uh-oh, I shouldn't have put it there. I'm not claiming points for it. I don't get any points for it. we always say book a consult because there's always variations on this, but it is important to explain what happened and why you're doing what you're doing when you go to submit your EAPR. So if you're not getting any points, you're going to put it into the personal history. You're going to explain, because it's going to give you an upload spot saying, you got to prove to us what her or his points were for Canadian work experience, and there won't be any. So you'll have to explain that carefully with LOEs.
Perfect. Our faithful follower, Spidey, says hello. He says, it's wonderful to see all three of us at the same time. And then we have another wonderful comment from Thembi. Thank you for all you do, my favorite immigration team. And apparently there was a smiley emoji, but I cannot pull it up. Okay, this one is a good comment from Oluwatobi, who joined us yesterday, and he says, I'm hoping the doings by the new minister will favor all applicants and intending applicants, improve PNP pathways, reduce timeline for new EE applications, and we share your excitement, Thembi.
Yeah.
All right. Raphael says, I'm going through the tiresome process of applying for EE. It can be quite confusing, and there were many fields I was a bit confused about how to fill. Your videos helped a lot. Thank you. And perhaps this is
Rafael
a good segue.
Coutinho. That sounds like a good Portuguese name.
Yeah. And Mark, I thought this is a good segue to once again reintroduce our Canadian Immigration Institute website and the Expert Entry Accelerator and a masterclass, which has over 10 hours of video lessons, templates, worksheets, tools, different tables that you can fill out and make the life of the officer much easier. And on top of that, you also have the master.
I guess that's tonight, is it? We got the
It is.
master class tonight. I just was looking at that.
Yeah.
I just look at my calendar, and wherever I need to show up, then I turn the camera on and point it to that person, and away we go. So I guess we're doing the master class tonight. Good stuff.
Yeah. So we invite you to go to our CanadianImmigrationInstitute.com website. You will see the breakdown of the lessons that we have, different modules. We have 25 different sample reference letters in the course. What else do we have? We have
just tons. There's pretty much an example of every document that you need. We're constantly trying to update our police clearance certificates. As we get new clients that have new ones, we redact those and share those as examples, because sometimes it's difficult to know if the one you have is the correct one. And obviously within the course, those are samples, just samples. But we have also, I think, like you said, over 30 sample reference letters and just checklists and tools and templates and all these sample documents designed to make your life easier. And let's face it, the main reason for most people applications get refused is because there's problems with the documentation. Translations aren't done properly. Proof of funds aren't established correctly. Reference letters missing something. So that's what it's designed to help people avoid the most common mistakes.
And speaking of translations, an interesting experience that I had last week was a consult where someone from Ukraine translated a document in Poland. And in Poland, they have their laws that require that translations must be done from foreign language into Polish and then from Polish into foreign language. So it creates this kind of this proxy translation. And RCC refused the application. And so this is something that you have to be very careful about. And they don't talk about it on their website. You will never find anything talking about how, will they even accept your proxy translations or not. They have some hints about direct translations from foreign language into English or French, but they don't specify the specifics of different variations of the translation that you can have. And so it only comes with experience, right? And come on, we had how many? 40, 45 now? I don't know. I lost track of how many years of collective experience we have in the firm dealing with all of these issues daily. So if you have any questions, if you are finding yourself in doubt, it's always a good idea to reach out for a consult.
You bet. I've earned this, you guys. I've earned this here. That's the gray hair.
Me too.
I'm starting. Like, it doesn't show up, but
This practice, it'll hasten the gray hair, Igor. It will hasten it.
all right. So Batman asks, can we expect provincial quota restored as previous year's levels, and when that can happen?
Oh, there's no crystal ball to rub here. I'll rub my head here. I'm hopeful. I'm cautiously optimistic.
Okay. Nabil asks, so I started as a project coordinator intern, got promoted after 4 months to project coordinator. Okay, so from intern to the coordinator. Do I need to list this separately in express entry and get 2 separate experience letters if responsibilities remain the same?
So, Nabil, it really depends on what is the knock you are claiming, right? And if that knock is the same, and as long as you were paid as an intern, so this is a really big, important factor to consider. If you were not paid as an intern, you cannot claim that work experience, either for foreign work experience or Canadian work experience. As long as you were paid for that internship, then it really depends on what is the essence of the main duties. So what were you doing, that opening paragraph of the knock, and then what about the job duty bullet points? Because if you're meeting a substantial number of those, then great. If that remains the same, then basically Igor's pulling up the proof of work experience. You can have your employer list both of those periods of work, your start date, your end date, your pay for that, the job duties for each of those periods on the same letter. And basically you upload that letter to both of those upload spots if you need to separate it out. Sometimes, and this is where booking a consult is really important, because we never want to give you advice without knowing all the nuances of your situation, because it can result in terrible things happening. So we always are very careful to say we need to understand everything that's going on. But some of the other reasons that people break up their periods of work experience would be, let's say they worked in a different location for the internship versus when they got promoted. Let's say the pay range was significantly different, or the hours were significantly different, or the job duties differed. So if there's something that really makes it a separate period of work, then you would break it off, but you still could upload the same letter from the employer to both upload spots if you get your ITA, but you will have to make sure that that letter from your employer properly breaks down both of those jobs and that you're claiming the correct knock for both of those jobs.
All right, perfect. This next question is really good. If the evidence submitted in response to the ADR for foreign employment experience is still considered by byRCC as not convincing, will they issue a second ADR or outright deny the PR application?
This is an interesting one. Okay, so the short answer is highly unlikely, you guys, especially for Clevy here, that if they didn't like the first response, that they're going to give you a second kick at the can. I have seen some very strange procedural fairness letter requests lately for express entry that I never would have seen before. So, for example, I have someone who was drawn under the Francophone, one of the category-based draws for French language. And I don't know if that's the reason why they're just being soft, but they included no duties in the reference letter, no pay slips or pay stubs. All they included was a bare bones reference letter for their work experience. And they got a procedural fairness letter on their work history, which is one of the ones that I'm doing here this afternoon. I can't tell you how many times I would have seen a person with a refused application coming to me in those circumstances. And then the other situation is quite similar, but the individual had to describe their role in the reference letter. It almost appeared like there were two positions, but there weren't. They just kind of had a kind of hybrid title that kind of encompassed two different occupations, even though the occupation really was more aligned to one. And so same thing. In that situation, I would have expected just an outright refusal. But for some reason, and you know what? Both of them, I think, were French. I don't know if there's another reason to learn French here, but I have been seeing a little bit more kindness, which seems kind of strange. No, not on all. These are anomalies. But yeah, very unlikely that, express entry is all about getting it right the first time, because often there are no second chances. And boy, when you get a procedural fairness letter, I strongly encourage you to reach out and at least book a consult with us so that we can talk through it with you. And sometimes you'll get a request and you won't know really what it's about. It'll just say, redo your Schedule A, your background declaration, and make sure you answer the statutory questions properly, or they'll put emphasis on a certain period of time in your history that you've recorded in your personal history or otherwise, where they want you to restate what you did. And those are kind of setups, almost setups for a potential finding of misrepresentation. Clearly, a procedural fairness letter in its very nature is designed to give you a chance to respond because they think you don't meet the eligibility or you're somehow otherwise going to see a refusal on your application, and this is your last chance to fix it. So yeah, I don't know if you guys think that I've never had a second, request for information. I haven't. I don't know about you guys.
No, if there's one request for information, that's usually that, sometimes they don't
That's a
even
miracle.
give a request at all, right? They're just going to
In most
refuse
cases,
you
they don't.
outright. They're
Yeah.
going to say misrep, or they're just going to say, no, you don't meet the program eligibility requirements and your application's denied. They might ask you for more information in that additional document request, but Mark is right. They're giving you, the nail to put in your own coffin if you give them information that's going to confirm misrepresentation. Of course, you have to be honest, and if there is something that's not adding up between your previous applications and your express entry application, that is something you need to
Yeah.
own and deal with. But I don't think I've ever seen 2 additional document requests. I think maybe the only time I might have seen it was with respect to military history. So somebody had mandatory military service, but they were not involved in, active combat. Immigration wanted to know more details on the military schedule, and then they gave them the details, and then they wanted to maybe know something about what was the commanding officer, or where were you stationed for this period of time. Basically, they're doing security screening to try to figure out if you might have been involved in war crimes or crimes against humanity. But no, they don't give you 3 or 2 chances most of the time.
Yeah.
All right. Welcome back to the super chats now. So one more from Raphael. I have the Globe and Talent Stream LMA. Can I have arranged employment points 50 points back? I'm learning French to control that damage.
Yeah. I wish, Raphael, I wish I could just say, wave my magic wand, poof, your points are back. But it just doesn't work that way, unfortunately. But it's good that you're learning French. And I guess, Igor, it's probably a good segue into Jenny's question there. I don't know if you want to jump back to Jenny Belikov, but it kind of fits into this mix. So Raphael, he says, I'm learning French to control that damage. And yes, that is a way that you can reacquire those 50 points that you may have lost. But Jenny says, come on, seriously? It takes at least 2 years approximately. And, Jenny's not entirely wrong. Like for an adult, like an older adult, you're in your 30s or 40s, it's not easy to pick up and learn a new language. It's challenging. It's difficult. I do know people that have immersed themselves in it and have acquired, maybe not like you indicated, it's really B2, that level for French, but they've done enough to be able to extend their work permit and buy themselves time. And that's why we always say, start now, start early, because it will take time. And when you're not immersed in that language, in that culture, in that country where all you hear is that language, the learning process is absolutely slower and it's not as effective.
Just as a counterpoint, Jenny, I literally had a client, and this is a very motivated academic client who is good with languages, but here's the thing, she already spoke 3 or 4 languages. And we did all the points analysis. I helped her with her study permit. I helped her with the PGWP. We looked at it, and I said, look, at the best thing you can do for yourself is learn French. And it's actually even better than hitting your 1 year of CEC, because she had foreign work experience. But the best would be CEC plus your French plus your foreign work experience. And so she said, all right, I'm going to treat it like a full-time job. And I'm going to spend 8 months, and I am going to intensively teach myself French, and I'm going to use all the resources. A lot of municipalities and libraries have like things where you can go for tutoring. They have resources, they have testing assistance, they have training programs basically. And she she went at it. She taught herself NCLC level 7 French in 8 months. And she got a round of invitations under a francophone targeted draw, and she is now a PR. So it is possible, but you got to be super motivated.
It is. And I have another client, a young girl and her mother who are here. We just finished filing restoration applications on their work permits, but she was able to, because she's an overage dependent now, and she was on her own after graduating from high school. She knew that she was going to need French. And so she studied. And in the same light, she was able to hit a 7 on some of the abilities, but at least a 6 on the others. And that allowed her to be able to apply through the Francophone Mobilité for her work permit. And yeah, I was very, very impressed. And it was a really short period of time, Alicia. Like, I think it was over a period of 6 or 7 months as well. So it's doable, but for the most, for most of us mortals, it does take time to learn a language. And so the best time to start is now and not wait.
Probably yesterday, Mark. It's better.
Yeah, probably, Igor. Probably. Yeah. Although with the, like I said, with the Liberals maintaining control over the government and winning the last election, Prime Minister Carney has indicated even an increased emphasis on Francophone immigrants outside the province of Quebec, even more so than what are in the current levels plans. So I'll be very curious to see what they're going to have for 2026 and beyond.
Yeah. All right, I propose that we jump to another super chat, which perhaps will require me to ring this bell.
Mm-hmm.
So IRCC only counts 30 hours of work. Does this mean that if I receive an average wage and work 30 hours a week, would IRCC accept my EE Canadian Experience Class PR application with no dispute?
With no dispute. Alicia, we just talked about this in our podcast. Okay, you guys definitely have to go back and listen to the podcast. It's going to be dropping here shortly, episode 167. Mm-hmm. Yeah, go ahead, Alicia.
So with no dispute, there are no guarantees, right? It all depends on the quality of the evidence that you are providing. And so please go take a listen of the podcast. I think, Mark, hopefully it'll get up and posted pretty soon within the next few days. But Mark and I talk on the podcast all about express entry, getting it right, and qualifying Canadian work experience. How can you count it? What happens with those 30 hours? If you are in a job where you're working an average hours, right? Maybe you have bi-weekly pay, and in 1 week you're getting 29 hours and the next week you're getting 31, but some weeks maybe you're getting 24 and the next week you're getting 32. This can become a problem. And so technically IRCC says you've got to prove the onus is on you over either a 12-month period. So over 1 calendar year, you can take a look and see, well, every week, did I hit 30 hours a week? If it's less than 30, to be safe, IRCC might not count it as a full week. You could also take a look at cobbling together different part-time jobs over a 24-month period to see whether you hit those 30 hours, 1,560 hours. But keep in mind that IRCC will not give you credit for anything over 30 hours. So technically, if you're working, 27 hours 1 week and then the next week you're hitting your 33, they say, well, we're not going to be able to carry those extra 3 hours backwards or forwards to the other week. Sometimes averaging might work, right? But as long as you are very clear with immigration, there's no misrepresentation, and you say, look, here's the job, here's the terms of my work, here's how I get paid for regular hours, because then there's a whole world of, what about overtime hours? What about statutory holidays? What about, vacation pay? Does that count towards my hours of work? So please book a consult. We can take a look at it and go through it in detail. It is something that there's a fair amount of risk, right? If you're not meeting your minimum eligibility criteria for CEC or FSW, then you're going to want to be conservative. You're going to want to give yourself extra time to meet your requirements before trying to claim eligibility too early in general.
All right, we'll move on to the next question.
It is hard, you guys. These are great questions, and understand we will not get to all of your questions. It just is not going to happen. If you have something, I see some people saying, please answer my question. This is really important. Book an immigration consultation. And then, because often those questions tend to be, what do I do? Book a consult and we can help you with that. But yeah, we will do the best we can in the limited time that we have left here to try to hit some of the high points.
Yeah, it's funny how we're trying to keep our live Q&As limited to 1 hour, but then sometimes we just have to extend those because we have so many good questions, and even though we still cannot answer everyone's question. So what I propose then is perhaps some new format. So starting at 11 a.m., we enter the blitz mode. We answer the question real fast and try to get through as many as we can. So I have pre-selected 15 questions that we have. So perhaps we can just run quickly through any of those. Maximum a minute per question.
I'm ready.
Okay.
Game face.
All right. So Ash is asking, is applying for a working holiday visa just after applying for PR invitations is acceptable? Will applying for two different things at the same time will have a negative impact?
Oh.
Okay.
All right, I'm taking this one. Okay, so keep in mind that you have to maintain valid status if you're going to stay in Canada, right? So depending on what kind of PR application you submitted, that may or may not be a requirement, right? Take a look. Some of the PNPs require that you stay working in that job for that employer with valid status on a work permit, and that's, tricky. So anytime anybody has filed multiple applications, they've filed a temporary resident application, either a visitor visa extension or a new work permit like an IEC working holiday, and they have a PR application, you've got a dual intent. And this is where it's important that you are making sure that you are honest with immigration, saying, yes, I've filed a temporary application, but I also have filed a permanent resident application. And here's where people usually go wrong. They don't take the time to cross-reference all their previous applications, especially if you've been here for a long time. So you might have visitor visa applications, you might have study permit applications, you might have PGWP, then your express entry, and now you're trying to do a working holiday. So there's lots of moving parts. So there are for sure possibilities for negative effects. You got to be careful.
Igor, you need to ask
Okay,
us more yes/no questions.
all right. Okay. There will be no yes or no questions. And let's make it even more fun. I'll select who's going to answer the next question.
Okay.
So that's going to be Mark.
Oh, dang it. Okay.
If a work permit expires in December 2025, but we renew it then, and no answer is delivered by December 25, do we still have to leave the country or we can remain in Canada?
Okay, Ari, based on what you've indicated here, if you have applied before it expires and then your permit expires and there has not yet been a decision made, you can absolutely remain in Canada on what we call maintain status until a decision is made. And you can continue to work under the same terms and conditions as the original work permit prior to submitting the application. What I don't know, Ari, if you submitted what I would call a frivolous work permit application. And the reality is there are some people that advocate just filing some random work permit just to buy time. I always caution people from doing that. But if it's legitimately an application is submitted before the current one expires, you can continue to remain in Canada. You don't have to leave the country until a decision is made on that application.
All right. I'll pick the next person who answers the next question, and that's going to be Mark, because the question is still related. So your thoughts on people applying for fake postgrad work permit extensions to buy some time to be eligible for bridge?
Yeah, I don't like it. I think it's, I don't think it's ethical, but at the end of the day, whatever you want to call it, like at some point you could expose yourself to misrepresentation. I think it's rare that would happen, but the act of filing that is going to absolutely result in a refusal, and then you've got a refusal on your record. And then if the circumstances are such, you will have an ability to restore your status. And I understand why people are encouraged to do it, to buy time, but boy, it's going to get rejected. And then if you're trying to then file for a bridging open work permit, then you're in a restoration situation. And yeah, you just have to make sure that that you're crossing your T's and dotting your I's. But I don't advocate for that with my clients. We always try to find alternatives, including a legitimate work permit extension application. For example, if there's any kind of specialization with what they're doing or any kind of a higher level, maybe we consider filing a C10, which is legitimate, have the employer register a job offer. And then we say, okay, we're pursuing an LMIA or whatever it might be. But that's my thoughts on that, Nabil.
All right, Alicia, your turn. The question is from Silicon. Do you need to put a high school education under educational history if you're not claiming the points for it?
So Silicon, it depends. You need to have some sort of qualifying education in order to have a valid profile. I'm assuming you're asking about this in the context of express entry, but there are different rules for different PNP programs. In general, if you're looking at express entry and you have higher education, so let's say you have a postgraduate certificate or degree or diploma, or you have a bachelor's or you have a master's, you don't need to put high school in there in general, because you're only getting your education credential assessment, or if it was Canadian education, you're putting the highest level of education for which you are receiving points. And then you will put your older education history in your personal history. So keep in mind that when they say education history in the express entry profile, it is what you are claiming points for that you then have to substantiate with your either Canadian transcripts, diploma, completion letters of certificates, or you have to have your education credential assessment for anything that's foreign education.
And I think the confusion exists because in the express entry profile and EAPR, they ask to put your secondary and post-secondary education. And so secondary, that's school, and post-secondary, whatever's after school. So perhaps this is why Silicon was asking this question. And we'll move on to the next one. Will the temporary foreign worker program come to an end? What about restaurants in rural towns seeking workers? What will happen? Please answer mine. I really need workers in rural Nova Scotia. I don't find locals here and PNP is blocked off to us. What should we do? And the answer to this question will be provided by Mark because he comes from a rural area.
Yeah. So understand we're in a difficult situation right now. We're hopeful that the PNPs will have more allocations returned to them. We know that some people, their only hope is through PNPs, but we're in a waiting game, and your job is to do everything in your power to be able to extend your work permit. So it's a war of attrition, those who are able to maintain their work status until this world resets itself and normal PR numbers go back to where they were before. But restaurants and rural towns seeking workers, what will happen to us? If you're in a rural location, there's a very strong likelihood that restaurant should be able to get a labor market impact assessment for you. So I don't think the temporary foreign worker programs are going to come to an end. They're always going to be a part of it. The PNPs, like I said, are the pathways for many people in these types of positions because express entry is just too competitive. So in your situation, when we're talking about the TFW program, it's rare that a rural location is going to have unemployment rates higher than 6%. But it's possible, I guess, if you're in Atlantic Canada, that is possible. But yeah, the goal is absolutely to have your employer support you with an LMIA if possible. And we'll just have to see. I think the reason they put these refusals to process for areas of unemployment higher than 6% is because they want people to leave. And it's as simple as that.
All right. Alicia, you're lucky to get the question from Silicon once again. This is awesome. Do you need to put address history of hotels even for short vacation stays?
And so Silicon, one of the things that I do with clients when they've hired me to help them review their express entry profile and their EAPR in detail is we very carefully go through what is your address history. Let's cross-reference that with your travel history. Let's cross-reference that with your claimed work experience and your education history to make sure that it all makes sense. When it comes to really short vacations, it is a judgment call. So I normally kind of use a rule of thumb. If you've been somewhere for a month or maybe even for 3 weeks, you're going to list that in your address history. You'll also have your travel history listing exactly when you left and when you came back. But you do want to be careful because It's important for you to tell the truth so that immigration then can go and do their background security checks and make sure that you're getting police certificates for any country in which you may have spent 6 months continuously within the last 10 years or since you're age 18. So that's why, and it does depend on how long that vacation was.
Okay, Alicia, and you're also lucky because you're gonna get the next question from Ankit. I have maxed out my language points as the main applicant. Now can my spouse learn French and file an express entry application targeting French categories separately, and me being independent?
Yes. Yes, you can. So this was an easy one. You can have each spouse create an independent profile. So in the principal applicant spouse, you can claim points for your spouse's language. And so if your spouse is learning French and that is going to increase your score, great. If your spouse is going to be the principal applicant on their own application because they actually have hit NCLC level 7, then yes, you can definitely have your spouse create another express entry profile as the principal applicant and list you as the accompanying spouse. So there's no rule against both spouses being able to have their own express entry profiles. I saw another question on here about having multiple profiles. That is not a good thing to do. So not having multiple profiles for the same applicant, but if you have 2 separate people, they can each have their own profile.
Okay. I'm going to pull up this super chat.
Yeah, I knew you were going to do this one, Igor. Yeah,
Okay.
go ahead and read it and I'll respond to it.
So I submitted an ECA evaluation twice with Wes. They came back to me twice with your education was done in Canada. My school had a partnership with Canadian School and diploma signed by both and done in 2021. Attached the email with the Wes. What do I do?
Sam, this is a perfect example of why you need to book a consult, because this is something I've never seen a situation like this. Alicia, I don't know if you've ever seen a situation like this. So is this considered to be Canadian Canadian education? I don't know, Sam. I would need to look at it. We need to figure out if the school was a DLI. How is it really treated? And then, yes, for sure, under any and all circumstances, I would attach an email from Wes if you tried to get an assessment and they said no, it's Canadian education, then I would absolutely do that. But ultimately, whether or not you would be eligible for it, I've never seen anything quite like this. So, Alicia, anything to add?
I've seen it once, and I literally asked the client to go get the transcripts from both education institutions because both education institutions gave transcripts. I asked to see everything that was submitted through Wes. I asked to see what the diploma looked like at the end. I wanted to see the completion letters to try to understand, because the problem is you don't want to mistakenly try to claim Canadian education and points for Canadian education and then immigration to say MISREP. So if it's foreign education, then claim it as foreign education. But if you're trying to claim those Canadian education points, then you've got to be super careful to make sure you've got something to back that up.
Okay, Alicia, the next question's for you again. Can I leave Canada after applying for CEC and complete all of the formalities from abroad?
And John, again, it depends on the circumstances of what you claimed points for, whether you were claiming arranged employment points. Probably not if you did a CEC application. The rule is that if you are in Canada and you were claiming Canadian work experience points, you have to make sure that you had valid temporary resident status and the authorization to work for the qualifying period of Canadian work experience. If you are going to go and leave Canada after your ITA, after your EAPR, then you have an obligation to update immigration with your current address, because the difficulty comes on the back end, right? So assuming that everything is perfect in your application, you meet minimum eligibility, you meet all the points that you've claimed and you can prove it. If you leave the country afterwards, then you must notify them. And then now it's a matter of, okay, does that affect maybe police clearances? Does it affect your ability to get your landing on your second stage? And so there's a different process for e-copers if you're inside Canada. If you're outside Canada, you actually need to physically send in your passport in order to get your landing visa. So it depends.
Perfect. Mark, your turn. And you have 2 questions which are fairly similar. Happy
Okay.
seeing all 3 of you together. Currently, we as a family have 509 points. The points will increase to 519. Do you think the ITA is possible? And the second question is, Do you think the points will drop to 530 in the next draw on May 27th? So both questions relate to points. What are your thoughts?
Okay, so we'll start with this last question about, do I think that it'll drop? It all depends on the number of invitations they extend. So the reason it was so high is because they only sent it out to 500. If they sent it out to, say, 4,000, like we have seen in the past, then I have very little doubt that it will drop below 530 points. Okay. So when people are asking, like Manura is asking Minu, is 519 going to be enough in August? Well, it just comes down to whether or not they're going to issue larger numbers, or whether or not they're going to stick to category-based draws. And I don't know, Minu, if you're just generally going to be qualifying through one of the regular CEC draws, or whether you have, work experience in one of the specific category specifics. I don't know. I'm assuming probably not. But your sole job, Minu, is to continue to increase your points however you can. And like I said, you start studying French. If you can scrape out 1 or 2 or 3 more points, maybe then that 1 point you get to push up to 520 is enough. And there's a round of invitations right at 520. So is it possible? Yes, it is. It just comes down to how many allocations, how many invitations the government is going to extend in that particular round.
Okay. Super chats keep interfering with our blitz. So this one's from Anmol. Anmol is asking, do you think the federal skilled worker specific program draws will be back? So the last time it was in February 2023. So what are your thoughts?
Yeah, we do know that they have said that they are going to try to prioritize people with Canadian experience, except for French. And so, if you happen to speak French on a targeted draw, then you don't necessarily have to have Canadian experience. We've not seen like a specific FSW alone draw for some time, but that doesn't mean that if you qualify for federal skilled worker, you're not eligible for an ITA, right? It just means that they're pulling you through a different stream if you meet program eligibility, let's say for a targeted draw. However, STEM is one of the ones, and I know Mark always says, let's take out the T because there's almost none of those left in there. It's probably the one where I think it has the least chance of getting pulled right now, just because of market factors and unemployment rates. And so my bet, if I had to rub the crystal ball, would be probably healthcare. I was surprised there was an education draw, but I would say healthcare is probably, and maybe trades are the ones that are going to be prioritized for targeted draws.
People don't want to let us go, so they're sending super chats. So this person is holding a postgrad work permit expiring in 6 months and waiting for the CC draw. Applying for working holiday visa to extend the status in Canada. Will this person be eligible to still get selected for permanent residence with a holiday visa submitted or acquired?
Yeah. Maybe, right? With your postgrad expiring and transitioning to a working holiday, if that's something you can acquire and you have that valid status, you can continue to count that Canadian work experience right towards CEC. So, short answer is yeah, it's possible.
Okay.
Yeah, it all depends on meeting minimum eligibility and having a high enough CRS score. And so, yes, if you need to get more months and years of work experience to claim those Canadian points, then make sure that you're hitting that maximum, right? So make sure you're trying to get 1,560 to meet minimum eligibility for CEC. You have to have a valid work permit while you are working. And then this is where it gets complicated with implied or maintained status, right? If you're switching from one postgrad work permit eligible category to a different category of work permit, you've got to make sure that that application for your working holiday is 100% correct and complete, so that you do have maintained or implied status to continue to work, but you've got to work under the same conditions of that open work permit.
Okay, and we'll keep going while the super chats pile in. This one is from Saturday Morning Toy Collector. So the question is, as a US resident who's wanting to relocate my family to Ontario and we don't have the required proof of funds for a family of 6, would I have a better luck trying to get a job first instead of express entry?
Yeah, this is the question, right? So we know that the removal of points still allows for assessment, and you can keep us all three on here because I need some support on this one, Igor. Um, we know that with the changes, it hasn't necessarily avoided the job offer points within the federal skilled worker program. We don't fully know. I don't know, Alicia. Maybe you can clarify this: the impact of having a job offer on the need for settlement funds. So if you're going through FSW and you have an employer who obtains an LMIA based permanent job offer for you, and you're looking to immigrate to Canada, but you didn't get a work permit to actually start working for that employer, will that be enough to remove the need for settlement funds? I don't know the answer to that, Alicia. I haven't looked that up. Do you know?
Yeah, so take a look at the article that Igor had pulled up earlier about claiming points and arranged employment, because this is where it's really important for settlement funds. So if you can properly claim those arranged employment requirements based on one of these three scenarios, then the regulations say that you don't then have to prove settlement funds. So this would make a really big difference for you, Saturday morning toy collector. So as a US resident, I'm not sure if you're just resident or if you're a US citizen. And there are some free trade agreements that are currently, knock on wood, still in existence under the Canada, US, Mexico Free Trade Agreement. So sometimes, so there's three scenarios. One of the scenario is having some sort of non-LMIA based work permit. So it might be possible for some people to actually get like an intercompany transfer work permit that's employer specific, or maybe professionals Canada, US, Mexico Free Trade Agreement work permit. In those scenarios, though, you have to have worked for a year under that work permit before you can then say, yes, I have arranged employment, and then the employer has to agree. It's great. So you're a citizen, so you might have options then under CUSMA or under an ICT. So if you get that job in Canada, make sure that you do the work permit properly. It has to be employer specific. The employer has to put in an employer portal offer. You work for a year under a high skilled job. Then you can say, okay, I do have arranged employment points as long as my knock is high enough. And then you can hopefully be exempted from the settlement fund requirement. So it's a long-term plan, but you've got to, please book a consult. You've got to make sure that you're doing everything properly.
All right, and this one perhaps will be the
Okay.
last question that we answer. And
Yeah.
before you answer, I'm gonna ring this
Yeah.
triangle.
Yeah. Yeah. Sam, it's hard. Go ahead, read the question, Igor.
Yeah.
We'll get it out there. Yeah.
So Sam submits a follow-up clarification on his question. So the school is in Canada, was a DLI. I'm just trying to claim education as a whole, not specifically Canadian. With no ECA, I can't do either transcript and diploma side by both.
Yeah. So obviously, Sam, in this situation, and sometimes people ask these questions to me, you have, if you need this education to score Canadian, CRS points to be eligible, then you have nothing to lose by going forward and fully explaining the situation to the officer, providing all the evidence that you have, including your attempts to obtain an ECA, providing your transcripts from the school, everything else. And obviously, a consultation will help us to brainstorm if there are other things in addition to this. But in these situations, when you're laying everything out for an officer, and you're not misrepresenting anything, you're not withholding anything. If you have nothing to lose, in other words, you wouldn't get an ITA without it, then I always proceed forward with it. But I fully explain everything. And if the school is a DLI, I can't remember with this one. Was any school attended while the person was in Canada? Like, was Sam in Canada, or was it? I can't remember if any in
I'm
class.
getting Sam is outside Canada.
Yeah, this is the hard part. So yeah, I really recommend you book a consult, Sam, because we need to dig into this. And personally, I've got to look. We'd have to do some more research and see if there's any kind of directives from immigration on this question. But regardless, if it just wasn't, if it wouldn't happen without it, in other words, if you are if you just don't have any pathway forward, then I will often push it.
Okay.
And I will add to that take a look at the ministerial instructions Ministerial Instruction number 11, sub 3, and it says education credentials. In order for a foreign national to be assigned points, A, their education credentials must be Canadian education credentials, or B, they must have an education credential equivalency assessment in respect to their foreign education credentials issued by an organization or institution designated under subsection 75 sub 4 of the reg. So you have to have either an ECA or it must be considered a Canadian education credential, and that's the question.
Yeah.
Okay. So on this note, we will be coming to an end and ending this live stream until next Wednesday, when we will reconnect all three of us together once again for another live Q&A where we will answer your toughest questions. In the meantime, we will again direct you to book a consultation with us at our website, holthelaw.com. So all you have to do is just type Holthe Law in Google, then click Speak to a Lawyer, select with whom you want to book a consultation. We have different availabilities, different durations for the consults. The price is all the same for all three of us. If you don't need a consultation, what else can you do? You can go to our Canadian Immigration Institute website, and we do have several courses out there. I'm still working on a Canadian citizenship application course. I just don't have time. I'm working all the time. I'm trying. But then, one other thing that you want to do, you want to go to our holthelaw.com website and read our blogs. We have written the blog post about the new minister, about the new changes in federal courts, the mistakes that doctors make when they apply for express entry, and so many other good content. Anything else, Mark, Alicia, that you wanted to add before we wrap it up?
Yeah,
Not really,
same thing.
other
The
than
resources.
yeah,
Resources have our podcasts too.
Yeah, the podcast, you bet. And episode 167 on Canadian work experience that Alicia and I just recorded today, it will be dropping in the next day or so. My our podcast editor, my son, is working on it as we speak right now. So we'll see if we can get this out here in short order. So subscribe, Apple, iTunes, or Spotify.
Yeah.
Maybe we need to put it on iHeartRadio too, right, Igor? I think that's another one, right?
Maybe. One other thing, a little sneak peek into what's coming. We're planning to roll out the feature where you can submit your questions in advance. Let's say you don't have an ability to attend the live Q&A. You can send your question. We will collect the questions through our website. So in exchange for your email address, we will answer your question. We do not spam our clients. In fact, we don't even send newsletters as often as we should.
Yes,
so if you expect spam,
because we're so busy. Oh boy.
Yeah. So
and let the Lethbridge folks know, Igor. I think in the Teams I put the Ukrainian PR info session. I don't know if you have the ability to pull that up, but we'll let people know if you are in and around Lethbridge and you're within the Ukrainian community. We are doing a special information session on permanent residence, Igor and I, at the end of the month. And so you definitely want to register for that one if you are in the territory. And we have a couple other things. I know I'm going to be traveling and Alicia, I think as well, to the CBA National Immigration Conference in Victoria here at the beginning of June. And then I'm heading down to Denver, Colorado for the American Immigration Lawyer Association conference as well. And these are definitely challenging times for us immigration lawyers. And we rely on those conferences to not only get the latest updates and information and practice, but also to console one another in our practices and to see our friends that we haven't seen for years. So, all right.
So thank you, everyone. Thank you for your wonderful questions. Thank you, Mark, Alicia. We made it through in 1 hour and 23 minutes exactly.
All right. Thanks,
Igor,
for
see you
hosting.
next week.
Yeah, thank you.